All right. Welcome, everybody, to another lunchtime update here. It's the lawyer you know. They just broke for lunch in the Kyle Rittenhouse trial. Today is Thursday. The defense's case in chief is on and moving. When we last met and talked in yesterday's live, Kyle Rittenhouse was being cross-examined. That finished up. Just a couple highlights of what happened there. He asked why he didn't just go home. He really pushed hard on why you had a gun like that if you were just there to provide medical help. Why were you there at all? And Kyle really tried to double and triple down on the fact that he was there to provide medical aid, and Binger kept pushing back on the fact that you don't need an AR-15 to provide medical aid. So we talked a ton about Kyle Rittenhouse's testimony yesterday. One of the big things that happened before court started this morning was, or it may have been last night, I can't remember now, the judge thinks the case could finish today, or Friday. I'm acting like the judge now. He thought yesterday was Thursday. Today is actually Thursday. So they think it could finish Friday, if not Friday, probably Monday. So this case could be to the jury on Monday. I am starting a trial next Tuesday, so I may not be able to give a live reaction to the verdict. Hopefully I will. If there's a verdict Monday, I should be able to. I should be able to go live Monday. Potentially if something were to happen. Just a little scheduling for you guys and for you to pay attention and keep track of. If not, at the end of next week, we can kind of talk about the trial together and the culmination of the full thing. Just to get through a little bit of the defense's other witnesses, Brittany Bray was an officer who did not seem to care to be there, basically testified that Gage's gun did have 9 bullets in it that night. The expert, Dr. Black, which I thought this was kind of interesting, before he testified, the judge asked, because it's Veterans Day, any veterans there, stand up so they could acknowledge you. Dr. Black was the only person to stand up. Round of applause for him. Thank you for your service, Dr. Black. And then he started talking about some technicalities of the video and how he breaks it down in timing. But when we got to his report, it was really interesting because the prosecutor said, "Judge, objection. This goes exactly against your pretrial ruling. And yesterday you reamed me out, basically, for going against one of your pretrial rulings. So what's going on now?" And the judge snapped back at the prosecutor again and said that was about the Constitution, not this. So the judge was angry about that Fifth Amendment push that the prosecutor did yesterday to Kyle Rittenhouse while he was on the stand. So Dr. Black, a couple of interesting things which we already knew about. Anybody that was here for that pretrial hearing, we heard him testify. We heard he was going to testify too. Some of the crazy just timing to think about. All of the shootings, everything happened in less than, I want to say 4 minutes. Is that what it was? 3 minutes. Everything happened in less than 3 minutes. The 4 shots that happened in the Rosenbaum incident happened in less than 1 second. The next 3 shots at Unknown Man, Huber, and Grosskreutz happened in a little over 5 seconds. So every time he pulled the trigger, if you add all that time up, it was a total of 6 seconds. So that's how quick all of this happened. And then the prosecutor tried to get at his bias. How much you get paid an hour? $320. How much has the defense paid you in this case? $9,000. So I'm going to ask you, the potential jurors, the people here. This is why you are so important to this channel. This happens in every case. How much have you gotten paid? So if an expert is getting paid for their work on a case and this is their job, how do you feel about that? Somebody that's not a lawyer, that might not be an expert, that might not testify. How do you feel about that? The fact that this person had to be paid to do this as a job. Does that make them less credible for you? Let me know in the comments. I don't know what we could say. So say expert if you think they deserve to get paid, or what is a nice word? We usually use not such nice words for people that are paid to say whatever they need to say. Let's just say money grab. Expert if you believe them, money grab if you think they're just there for the money and they'll say whatever they're paid to say, and you really think that that shows a big bias, that they get paid these high hourly rates, they get paid $9,000 to come help on a case. So the last witness that's on the stand when we just took this break was the most interesting to me. So we'll talk about it, and then I'm going to get to your questions, as always, in the chat. But I want to talk with you guys about this last witness, Frank Hernandez, a.k.a. Drew, who's a professional commentator. So to me, this was a very interesting witness for the defense. On one hand, I think it was very important. He witnessed, videoed, turned the video into the cops, that Kyle Rittenhouse was de-escalating the situation, that Rosenbaum was the aggressor, that there were these riots going on. It was violent. They ambushed Kyle Rittenhouse, lunged at him, tried to grab his gun. Kyle Rittenhouse was acting in self-defense, basically. He didn't say those words exactly, but so he testified as boots on the ground to all this stuff that's really good for Kyle Rittenhouse, right? So a very important witness. I understand why they called him. But his testimony, in my opinion, some people in this chat may disagree with me, about Antifa and these violent, riots and people that were crushing things to throw rocks at them, and these and when he talked about his websites that he works for and his commentary he does, he is, in my opinion, obviously politically charged. I don't love that. I think that if I was a juror, would make me, he seemed less credible to me because of all the political charge statements he was making, whether or not you agree with his politics. Like anybody that seems that obviously hot about that subject, it seems to me like he thinks Kyle Rittenhouse is a hero for, shooting people in the streets. And that's like kind of what he came here to testify to. That's what the feeling I'm getting is. I don't know this guy. And I think it's important that he says he's never met Kyle Rittenhouse, doesn't know Kyle Rittenhouse. But anybody that takes the stand under oath and testifies like this guy kind of has, he, to me, seems like he has an agenda. Obviously, Gage has an agenda. Kyle Rittenhouse has an agenda because their lives are on the line, basically. They're the alleged victim and the defendant in the case. This guy is supposed to be a witness. So to have him be so invested in it and, he really you guys let me know what you think. Do you think he was really charged and feels like he has an agenda and the jury's going to make him a little less believable than some of the other eyewitnesses that may have been there? I keep going back to McGinnis because to me, he's the one that seems like he's got nothing to prove. He's got no agenda. He was just there documenting it. It makes sense why he was there. He didn't use any political charge statements. You don't know what side of the aisle he's on. And he was just testifying to what's happening, right? People are going to have their political opinions. I don't mind that. As you know from this channel, we just try to keep it unbiased and straight when we're talking about legal cases and you're testifying in court, because I don't know how he can prove half the stuff that he's saying. And I think his testimony would have been a lot more effective if he just would have said, I was there documenting it as a commentator, and this is what I saw. Rosenbaum did this. Kyle Rittenhouse did this, and he just said it like that. But all the extra jargon he's got to throw in, I'd be willing to bet that Rittenhouse's lawyers wish he would not have said all that stuff, but he's just going to say what he's going to say because he probably has a persona on his YouTube channel and independent website that has a following that expects him to do this when he gets on that stage. Now, I could be reading a little too much into it. You guys tell me what you think. But Mr. Binger on cross, as only Mr. Binger can, when you have a witness like this who I would think it'd be easy to make look like a jerk, instead, Mr. Binger looks like the jerk with his sarcasm and his smug questions like, do you even get paid to do this? Okay, so besides this piddly website that pays you, does anybody else? And you gave us this video through your lawyer. Here's the problem I have with that, right? Judge had a problem with it, obviously. Defense had a problem with it. They objected to it. The problem is, what you're inferring, Mr. Prosecutor, is anytime someone hires a lawyer, they did something wrong, which is, in fact, false and a bad faith type of question, in my opinion. You should not intimate, especially as a prosecutor in a criminal case, that anytime somebody hires a lawyer, they did something guilty, they are guilty, they did something wrong. That's horrible, in my opinion. That is one of the worst things he's done in this case, because that's in fact against the law and against the rules and against the code of ethics that lawyers have. Because that's a right in our country to have a lawyer to represent you, especially in criminal cases. It's also a right when you see all this stuff going on and you don't trust the government, which people on both sides of the political aisle at this point don't trust the government for one reason or another. So there's nothing wrong with this guy getting a lawyer to turn something over to law enforcement to make sure, hey, is there anything in these? A lot of craziness was happening that night, not to mention the curfew. So by him showing this video, is he admitting that he was there breaking curfew? Could that have been a criminal action? So there's a million reasons why this guy could have a lawyer. I'm not sticking up for this guy. I'm just saying this question was so bad, and Binger steps in it again, in my opinion, and the judge lets him have it before we break for lunch. So let's talk about the questions you have in the chat. I just saw one come up that's interesting to me. How are facts political? Binger was the one asking him to divulge his connections. I'm not talking about Binger's question. If you watch the beginning, the defense lawyer says, so what were you doing there? And he said, I was documenting the riots, which is fine. Rittenhouse did this, Rosenbaum did this. But he was saying definitively, Antifa was doing this, BLM was doing that. Listen, I'm not saying any group does or does not exist. I'm not saying what they stand for. I'm not saying what they believe. What I'm saying is he'd be hard-pressed to prove who at those riots or protests or demonstrations was a part of any group with masks and shirts over their face and people saying one thing and doing another, some of them having guns. Those are not facts, in my opinion. And I would have objected to all of that if I was the prosecutor. They're not relevant and they're not facts. This case is not about what political party you belong to. It's not. I understand that there's a lot of political charge stuff going on in the background and could be pressuring the jury one way or the other, but that's not what the testimony's been about. And it can't turn into that, in my opinion. That would be bad for both sides because that's potentially an appealable issue. So that's what I mean by facts. I've got no problem with his facts. I think his facts are important, and he did a good job explaining his facts. I'm not talking about that. And I do think Binger has stepped in it a couple times already with him, and I assume he will continue to do so. All right, so let's get to the questions. If you have some, put them in the chat. There were so many yesterday, I wasn't able to get to all of them. So make sure you get them in now. Thank you, Vuzu. I don't think I said at the top, if you do not subscribe to our page, please go subscribe. Keep following along with these cases with us. We'd love to have the questions and answers and the talk back and forth in these lives. And make sure you like this video, please. Marlene, glad you're able to catch some lives. So this is good. So Redbeard, that witness was great. Everyone's saying the same exact story. Case closed. I'm not sure which witness you're talking about. Probably the Hernandez guy. I agree. His story lines up with Kyle. It even lines up with the victims. I mean, at this point, everybody's kind of agreeing that Rosenbaum jumped out of the car and lunged at Kyle while the guy he was with fired his weapon prior to Kyle firing his weapon. Those are all facts. I was hazy to me before this trial, but I feel like that is what has come out in this trial. Yeah, I'm not going to agree with you. I don't speak ill of the dead. If we've learned nothing else, that Rosenbaum was a character, basically, is how I'll just leave that. And I agree. I mean, I think a lot of the testimony is the jury is not going to feel sorry for him. That's the important part. I don't think they're going to feel sorry for him back there. Yeah, Maxine, judge getting ready to read the prosecution again. Yeah, we just talked about that. I mean, it's crazy. Yeah, Marlene, I said this on my last video. The judge gets so aggravated, he literally looks like he blacks out. And then he's like, what was I saying? A couple times he said that. Paula, it happens. The judges do lash out from time to time. They're just usually not being watched nationally by thousands of people. Jesse Hidgen, thank you. We're glad you're here. And there will be another update coming Monday of next week for the Elizabeth Holmes Theranos trial. Pete is following it every week. It moves at a much slower pace than this trial, though. So, Marlene, I know I haven't seen a judge get so angry at the prosecution. It was very rude and pompous, like everything is beneath him. He has been very smug throughout the process. And it's, like I said, I mean, somehow he even looks like the bigger jerk here with this witness. But it is not a good look, in my opinion. And then the other thing, oh, gosh. So while this Hernandez witness is here and they're arguing about whether or not they can ask questions about the lawyer, the judge says, why does it matter if he has a lawyer? And the prosecutor said it goes to his bias and his credibility in front of the jury. These speaking objections are supposed to happen outside the presence of the jury. The judge eventually sends them out, but too much is coming out in front of the jury, in my opinion. But it's unusual for the judge to get mad at the prosecutor, not for them to get mad. So Claire Morrison, I'm only getting bits of this trial in Scotland. Is there evidence that it was self-defense? And was this during the Black Lives Matter protest? So we've done, I don't know, 10 videos on this trial. I encourage you to go check a couple of them out. I can't go through all the evidence today because a ton of witnesses have come out. But all of your questions would be answered in the videos. So in my opinion, is the judge showing any bias? I'm curious about your honest opinion. I don't like the word bias, okay? I'm not going to say the judge is biased toward one way or the other. This does seem like a judge who protects the defendant's rights, as I think all judges should. The benefit of the doubt should go to the criminal defendant because of the constitutional protections that they have. He's definitely not showing a bias toward the prosecution, which a lot of judges do. So maybe that'll answer your question. Rodney Williams, I'm in the wrong business. I assume you're talking about the expert witnesses. You have no idea, man. You have no idea. We have some experts in these car accident cases that work for the defendants that have made over $1 million for one car insurance company testifying, not doing surgeries, just testifying about injuries that plaintiffs have, that they've gone to surgery. And though they didn't need the surgery, they were perfectly fine. They literally make millions of dollars doing that. Just as an expert witness, they don't even have to do surgeries. So Paul, he thinks the expert testimony is not crucial to the trial. Marlene, money grab. Some people say an expert. I think somebody early on said, and I may have missed it, expert, you're supposed to get paid for what you do. And I agree with that. Oh, here we go. Expert, why should someone not be paid for their job? I totally agree. I think experts should get paid. I think, though, when you are a doctor, a practicing doctor, and you make more as an expert than you do as a practicing doctor, that's when I have a problem. If your job, you're retired law enforcement or something, and this is what you do, I've got no beef with that. I agree with you. They should get paid for their job. Nice. They do work that needs to be done, and lawyers can't be expected to do it. Chris Kircher, you're correct. Yeah, Rodney did what they asked him to do. Good. This makes me happy, actually, because in almost every case, we have to have an expert witness. So the fact that, you guys, if you were on my jury, you'd be like, yeah, the guy's there just doing his job. You can't hate on him for getting paid for what he does. All of us get paid for our work. So good. Good. Some great answers in this chat. So I appreciate all you guys. That's a good point, Tristan. Expert, this case is dangerous. Everyone's at risk, knowing how today's world is. No matter whatever side it comes out on, hopefully nobody does anything stupid with the jurors or anybody involved professionally in this case, or at all, I should say. Can the law firm that's going to be an expert witness, can they disclose that to a potential client, or is that confidential in law? I don't understand the question. Sorry, I thought I did it first. Try rewording it. Maybe I'll get to it if I can. Yeah, I agree. For staying out of the political subjects, they walked into it. I cringed for sure. You never know what a juror thinks, right? That's the point. Me as a lawyer, I want the juror just to focus on the case and the facts of the case. If you say something politically charged, certain people in the world today will totally disregard everything else and just vote their political party. That's not what you want on a jury. That's not what you want in a case if you're a lawyer. Caitlin Clary, is it normal to bring someone up? I'm sorry. Is it normal to bring up someone getting a lawyer as a possibly, I don't know, I can't read, a way to possibly discredit them? It depends. This is not one of those ways, because he was providing something to law enforcement. And I would just say, if I was him, anytime I deal with law enforcement, I have a lawyer there because I don't know what they're going to do. I don't know if I'm doing everything right. I want to just make sure my rights are protected. That's why I had a lawyer. But if it's certain ways like Dominic Black, who has criminal charges, that can show that he's got a lawyer, that can show some bias with him. And the victims that are filing lawsuits, to show bias that way. It's more towards the lawsuits, not that they've hired a lawyer. So sometimes. Brandon Reed. This is it, my friend. He seems obviously biased / politically charged to me, but the video he recorded shows what it shows. Exactly. And that's why his political affiliation doesn't matter. Frankly, it'd be better for himself. I assume he wants to testify to help Kyle Rittenhouse. He would help him more if he just left politics out, let the video show what it shows, and explain what he saw, because he obviously believes he saw self-defense. So New Chris, no. He wanted to get into all sorts of other things. Said the prosecutor mentioned that this commentator is biased politically. Judge didn't want to allow it. The witness brought in politically charged comments. So the prosecutor is trying to dig into it more. I don't know why. It's already out there. We are allowed to take the next step as lawyers in closing arguments. So he can get up there in closing arguments and say, this guy is obviously politically charged. He's here to get more followers on YouTube. He's here because he wants to help his side, his party. He wants to fight against this party. You can say all that. You can say he's politically charged. Digging into it more in the question is asking things that are not relevant. So it's not supposed to come out. So the judge is right to keep that out. And the questions about the lawyer, same thing. He's already got, in my opinion, Binger's already got what he needs to discredit this witness in his closing arguments. Now, can you discredit the video? I don't think so. But discrediting things that he said, I think you already have enough to do that. And he's done it over and over again where he's asked these questions that he didn't need to, in my opinion. The defense brought up legal representation on prosecuting witnesses, so I did explain that as well. Hopefully that answers your question, M4SL. Dick Sensei, if the glove don't fit, you must acquit. Tim Wheat, yeah, I don't. He didn't need to do that. He really didn't need to do that, in my opinion. He could have just, and I'm not saying anything politically about him. I'm just saying he didn't need to talk about it at all, whatever side he's on. So Tickled Pink, Peter, don't you think this judge is biased toward the defense? I can barely watch how mean he is to Binger. I think he should have been dismissed. So I assume you meant the judge should have been dismissed. I've said it from the beginning. It seems like he's got to lean to the defense. I've said it since the beginning. Bias is not a word I like because I don't think a lot of judges are biased. But I definitely think he's got to lean to the defense in this case, and there could be a lot of reasons for that. I got to be honest with you. His reactions to Binger are not out of line, in my opinion. They're maybe surprising because we get to see him in live TV, but Binger is doing things that not a lot of experienced DAs will do. So I don't know if I agree with the full comment, but I thank you for it. So this is interesting, Marlene. Barone, I know it's the prosecutor's job to get a conviction. However, I feel he was beyond what he needed to do. This is not a prosecutor's job. This is something they teach you at a prosecutor's office, which I learned there. And it's something we remind prosecutors of all the time. And 99% of the time, they agree with us. A prosecutor's job in America is to get justice and find and deliver a just result. Many times that ends in them null prosing or dismissing charges against the defendant when they realize it's not warranted or realize the evidence doesn't point to that. And when they feel it does, they go try to get that conviction because they think it's just. But it's not their job to just go get convictions. And a lot of prosecutors forget that at certain points throughout their career. His attitude is off-putting, but I agree, but it is equal. I think we're talking about Binger here. Oh, great question, Cassandra Stokes. Can a judge change a pretrial ruling if once the trial starts, she finds a compelling reason to do so? If he decides so or decides out of harmony with a pretrial ruling, is that grounds for mistrial? So no, he or she, no was a bad way to start. There's multiple questions here, so I'll answer them with an explanation. A judge can absolutely change a pretrial hearing. Sometimes it's frustrating as a lawyer because you didn't prepare that way, but if something comes out that changes the judge's mind and makes a piece of evidence relevant that wasn't relevant before. Or you'll hear lawyers argue a lot, they opened the door. So we want to talk about something, but they say, no, no, no. But they ask something on their side. You say, Judge, that opens the door. Now we get to talk about this criminal conviction or whatever it may be. Then the judge can change his pretrial ruling that way as well. And it's not grounds for a mistrial, unless it's actually, it could be, I guess, potentially grounds for a mistrial, but the lawyer would have to move for a mistrial, depending on if it's a huge piece of evidence or a witness we didn't expect to come in that's now allowed to come in. You could ask for a mistrial. It's not likely to happen that way, but yes, they can change pretrial rulings. That's a great question. All right, new Chris. Why is the defense so obsessed with mentioning Rosenbaum's use of the N-word? People of all skin color, background use that word as a term of endearment. I don't agree with it, but it's true. Oof. I don't think that I don't think everybody uses that word as a term of endearment. I will disagree with you there. I will give you my guess as to why the defense keeps bringing it up. Because the defense probably doesn't feel negatively about BLM or about Black Lives or anything like that. And they want to show that maybe Rosenbaum was not there as part of BLM. Maybe he was just there to start trouble. I think that's what they're trying to do. They're trying to show Rosenbaum wasn't there for some cause as a demonstrator, but instead he was there all night trying to cause a fight. And that's why Kyle Rittenhouse had no choice but to act in self-defense. That would be my guess as to why they keep bringing it out. Now, does that actually prove that? I don't know, but I think that's probably their attempt. Really put me on the spot there. All right. All right, Chris. Yesterday in the afternoon session, prosecutor kept hitting on the fact that Huber and Jump Kick guy didn't have weapons. Does he think a skateboard's not a weapon? Well, Gage Grosskreutz totally blew that argument out of the water for the prosecutor because he said the kick to the head and the skateboard to the head could have caused serious head trauma, and he was worried about Kyle Rittenhouse. It's a prosecution witness saying that. So, Brian Money, I didn't really talk about this. You want to hear about Binger's objection to the video expert analysis that went out of the scope of the court order. Technically, it wasn't true because a lot of the stuff the court said he couldn't testify to, he was no longer going to testify to, which is what we call ultimate issue, like that Kyle Rittenhouse was acting in self-defense and it was appropriate and he did have risk of great bodily harm. That's the stuff Dr. Black wanted to testify to. I shouldn't say that he wanted to. The defense wanted to elicit from him, and that's what the judge said he couldn't. There were some different nuanced labels that he made. The judge made him change the labels and then let him testify. All right. Doug D, does the judge scolding the prosecution or the defense, that affects the jury in their decision? I think it does. You guys tell me. If you were a juror and you saw a judge snap at the prosecutor over and over again. Now, the jury has not heard some of the really big screams or scolding that the judge has done to Binger. They have heard some little ones, but the big ones we're talking about, the jury's been outside the presence of the courtroom at that point. Do I think it would have benefited Kyle not to take the stand? I think he should have taken the stand because I think the jury wanted to hear what he was thinking, why he did what he did, and explain it from his own mouth. I think in this case, I probably would have advised him to testify. So, Brandon Reed, I've seen some people claim that Kyle being convicted of murder would set damaging legal precedent regarding self-defense. Is that in any way a true possibility? I think the fact that we have these videos and this testimony that yes, it could make self-defense a much harder defense in the future, because this is starting to seem like what the law was written for self-defense, based on the testimony and evidence that we're seeing even from the coroner. He wasn't shot in the back. Those little nuances are important for legal arguments in the future, because in the past, if you shoot somebody in the back, usually that's not self-defense. If they're retreating and running away from you, which is all things that we heard, that Kyle Rittenhouse chased Rosenbaum, that Rosenbaum was shot in the back. That's kind of what we heard before this trial started. Nabi, what are your thoughts on the defense saying the Apple Pinch and Zoom manipulates video? Some other people have asked that too. Love you. Thank you. I wouldn't make that objection. I wouldn't make that argument unless they can prove it. I mean, they have Dr. Black who can talk about whether or not it actually manipulates it, but I don't think it does. Is exercising the right to an attorney basis for bias? Asking for Binger. Good one, Xander. So I've already hit this. Absolutely not. Absolutely not. That's sad that a government lawyer thinks if you have a lawyer, something's wrong with you and you've done something wrong. That's the opposite of how it should be in our world. And you should realize that. And that's why you should like lawyers and come and know some lawyers. Tickled Pink, shouldn't the judge apologize for how angry he got? I think the judge feels Binger should apologize for his actions. And judges have gotten way angrier in courtrooms before. So Doc Sully, would the prosecution have been more successful if they had charged Kyle with second-degree murder or lesser murder instead of first-degree murder premeditated? I don't think so, because self-defense would have been the same defense. What I would do, though, I was thinking about this as I'm watching. I would go to the defense at some point if I'm Binger and say, hey, why don't you just plead to the gun charge and do 6 months in jail and then get out and have something on your record and we'll dismiss the murder charges. I assume one side of America would be in an uproar, but at least you'd get something out of it. I would try to work a deal if I was Binger. I'm sure no deals are on the table, but I would be trying to do that as a prosecutor to get something out of it, especially the one that I felt most confident was actually just. So Gene Hood, no, self-defense does not go away after the first shot. Just legally speaking, it can, depending on the circumstances. Like I said, you shoot him, he's not dead. You walk over to him while he's laying on the ground and then put another bullet in him, or, that obviously could change the circumstances. So Zachary Hoosier, who pays the expert? The lawyers that hire him usually. If it's a government expert, obviously that's the government paying them. But in a criminal defense case, criminal defendant is actually the one that pays them through their defense lawyer. And on civil cases, the clients are the ones actually paying them through the law firm. In most states, they get like $9 a day or something. So do jurors get paid, is Hankey's question. Great question, Tim Wheat. Binger said several times in his line of questioning was to impeach the witness or his testimony. What does impeach mean? Impeach basically means to say they're lying or they changed their testimony. So a lot of times we'll have a deposition and I'll ask a question and they'll say, yes, I ran the red light. But then when we're in trial and they say, no way, I had a green light. Well, Judge, I'm going to get into their deposition now to impeach them and say, look, when I took your depo 6 months ago, you said, yes, you did run the red light, right? And they said, yes, that's what I said there, but I didn't say it, but that's not true or whatever. Like Marshall, he's saying, no, what I said was a total lie. But you still get to impeach them and show the jury they had an inconsistent statement at another time. So impeach basically means to show that they're not telling the truth now. All right, let's see what else we have here. All right, New Chris, why did the judge not allow the DA to mention that picture Kyle took with the Proud Boys flashing the white power hand sign? For the same reason that I said this commentator, Hernandez, should not have talked about anything political. Political affiliations are not relevant in this case. They weren't charged as hate crimes or anything like that, so that it's just not relevant. It would just be to, disparage somebody or make them look bad or hope that a juror doesn't like their political affiliation and therefore convicts because of their political affiliation. That's not how we get convictions in criminal cases in America. Does the jury have to come back with a unanimous verdict? Yes, they do. If they don't, it's a hung jury, and we will do this trial all over again. So, Joy, why do lawyers try to get clients to admit guilty pleas even if the person is innocent? I wouldn't say that we try to get clients to admit guilty pleas ever if they're innocent. I will tell you that clients sometimes weigh the options, and it's a really unfair system. I agree with you. And sometimes you get punished for exercising your right to a trial. That's something I've been fighting against with the prosecutors. They'll up the punishment if you want to take it to trial. But sometimes clients weigh the risk of going to prison for the rest of their life or taking a plea deal to something they say they didn't do and going to prison for 2 years. It's an unfortunate reality of our system. No Simps 247. What do you think is going to be the outcome so far? I am definitely leaning towards self-defense and a not guilty verdict so far. We'll see if that changes. The gun charge, I think, is the only one potentially there could be a guilty verdict on. Thank you, New Chris. Thank you, No Simps, for the question. So, John Williams, I think, honestly, this is not something that's been a big question of mine. You guys can let me know if you do. It's not exactly like he was sitting in a normal situation, which is my big beef with Kyle Rittenhouse, if I have one, is why are you there, 17-year-old kid with a gun going into a hostile situation to protect car source? Like, I have a mental block with that. Does not make logical sense to me. But I think once things started transpiring, the way the laws are written and the way the evidence has come out so far, I'm leaning towards a not guilty because of self-defense verdict so far. But I don't think he was exactly in a normal situation where he could just call 911 or turn himself in. He explained that when he took the stand. There was nowhere to run. People were this way, people were that way. I was trying to run to the cops. I did try to turn myself in, and the cops sent me away. So I think he has explained that. So, Tim Wheat, this is interesting. The defense should do more to show how much a skateboard weighs. It's been impounded as evidence. They should get it. They do not have the skateboard. So that's something that the defense attorney argued in opening. We wish we could show you the skateboard, but Huber's fiance, I think, never turned it over, wouldn't give it to the police even after they ordered her to. So they don't actually have that skateboard. Interesting pickup by you. So, toss spot, there is a jury instruction that you as a juror get to weigh the credibility of every single witness that takes the stand. So one juror may dismiss it as biased, one juror may not. Thank you, Kirsten Larson. Learning's what we're here to do. So, B. James, how can they justify a person illegally carrying a firearm and then claiming self-defense after using it? Two different charges. So he can get convicted of the gun charge, and then also once it came to self-defense, he can still get off for self-defense. They're mutually exclusive. So Maxine Odell, why make a deal? And Maxine is saying, basically she thinks Kyle's winning in a landslide at this point. If it was me in my life, I would probably make a deal, if I'm being honest. If I'm Kyle and I can just get the gun charge and I don't have to worry about getting convicted of murder, I'd probably make a deal. You guys can disagree with me if you want. But God forbid if I'm Kyle and this jury doesn't see it the way that I see it, because you never know what people on a jury are going to do. M4SL, we try really hard. It is part of our mission statement. No name calling. Let's just talk about it. We all probably have different views on a lot of things in here. It doesn't mean we can't have fun and discuss this trial and learn from each other. I learned potential jurors' point of view. You learn from a lawyer that's tried cases like this, and it's actually an enjoyable time. Thank you again, New Chris, for another super sticker. So Logan, when will this be done? Probably Monday, it sounds like. It sounds like it's possible Friday and possible that it drags into Tuesday, but probably Monday at least it's going to go to the jury. We don't know how long the jury is going to deliberate for, but it seems like the jury's going to get it, I would guess, on Monday. And I have a trial starting Tuesday, so if we get a verdict Monday, we can talk about it Monday night. If not, probably going to have to kick it till Thursday. Animal science, I've been saying this the whole time, and that's the other reason why you potentially make a deal. With how split America is politically, do you think there won't be one stubborn juror? Hung seems so likely. I hate to agree with you here, but that's what I said when the jury selection went so quickly. I was like, man, if somebody on either side really wanted to get on this jury, I think they could have with how kind of lax that jury, that voir dire was. So Diane Braun, my thoughts on the prosecutor's misconduct during the trial and consequences after the trial. I was floored when the judge on the record said that he thought the prosecutor acted in bad faith. While the defense was making the argument for the mistrial with prejudice, meaning they can't come back and try to, it's very unusual, very rarely happens. They gave some exceptions, and it's when prosecutors act in bad faith or try to throw the trial in order to get a retrial when they think that they are losing. And the defense said, we're not going to make a call saying we're winning. If the judge wants to make that call, they can. But the judge has to make a call. And the judge said, I don't think you asked those questions in good faith, Mr. Binger, which was not great. He took it under advisement. I don't think it's going well for the prosecutor here. Whether he wants to win or wants to lose, if some have said, could have done a better job on either direction. Marlene, yes, Dominic Black was charged. He talked about that. He hasn't taken a deal, no immunity yet, but he's waiting until after this trial is over to resolve his case. But yes, he was charged. Thank you again, New Chris. Great question, Tim. You're coming with all the heat here. I know a defendant can appeal a guilty verdict. Can the state appeal a not guilty? No, because there's no double jeopardy. Sometimes, in very rare circumstances, there could be something happen like fraud on the court or something like that. But for the most part, in a case like this, the jury's or the state's not going to be able to appeal. All right, we got a few more minutes here. Any more questions? So Bucky Banshee says, if I'm not guilty, I'm not guilty by all the info I've seen in the trial presented. And that's, everybody's got to make their decision. Southern Sass, thank you. Oh, yeah. Brandon Beck, can the prosecutor offer a plea deal once trial started? There's never a time you can't make an offer. The jury can be out deliberating and the prosecutor make an offer. Same thing in civil cases. We could do the whole trial, ask for our number. The jury goes back and deliberates. And if the insurance company makes us an offer, we can settle the case before we ever know what the jury says. Thanks, Doc Sully. Everybody's decent and civil in this chat. It's a pleasure being around adults for once. I agree. It's nice. So, Henke, this is important, okay? Why did the judge get so much anger at the prosecution and the defense? Like when the defense tried to say Gage had a financial interest, which was thrown out for lawyer-client privilege. It was not thrown out. That's absolutely relevant. If you're suing the defendant and you're a victim testifying against him and you filed a $10 million lawsuit, you have a financial interest in the outcome of this trial. If the state wins, your case gets better. If the state loses, your case gets worse in civil court. Those are questions legally that you are allowed to ask to a victim in a case. You're not allowed to ask some witness or infer that because some witness hired a lawyer, they did something wrong when all they are is an eyewitness or turn something over to the police. You can ask a lawyer if you have a good reason for it, but not just to infer that they must have done something wrong, and that's why they hired a lawyer. So there's a big difference. So, Paul, I don't think the prosecution offered a reasonable plea. If they did, I don't feel Kyle would have accepted. Your thoughts? I don't know what they offered, so it's hard for me to guess at that. Yes, Kirsten, we all learn from different opinions. Safe here. Trial's a different story. So, Cassandra, can a judge or a lawyer come under review for their conduct during trial? If so, how does that happen? So yeah, the bar governs all lawyers in the states, like the Florida bar in my state, Florida. If they saw this case and felt like I did something unethical or in bad faith, they could reprimand me just for my actions in the trial, whether or not somebody reported me, or a judge, same thing. Two folk 13, they'll probably be back. I didn't hear when they said. I would guess in about 20 minutes. We'll be done here in about 5 or 10 minutes. Marlene, they can negotiate anytime. So, Brian Money, if the Rosenbaum shooting is self-defense, wouldn't the other ones be self-defense? Since the mob was chasing him in a justified situation as well. So no, each one, he had to be in fear for his life or imminent danger, imminent bodily harm, each time he pulled the trigger and used deadly force in reaction. Each time had to be its own self-defense. I have watched a lot of this trial, not every second of it, obviously, but I have watched a lot of this trial since the beginning, even before some of the hearings and stuff I was following. Good question, Brian Money. Can a crowd or group take action against someone attacking him based on the words of others alone? Sorry, I didn't read the second part before I popped it on the screen. So no, usually you can't use deadly force for just words alone, but there is the stand in your shoes doctrine where if you're somewhere and someone has a gun pointed at someone, they're about to kill them, you can use deadly force to step in and stop that and stand in the shoes of the potential victim. If they could have done that action in self-defense, then you can use that self-defense to protect them. I don't know if I explained that very well. It may have been complicated. But so there is the stand in your shoes where a group can actually stand in and help somebody that is getting hurt. It has to be reasonable. It always has to be reasonable. So SEBA, once you waive, that's very important. Good question. What stops the defendant from being directed and then invoking the Fifth Amendment on cross? Once you take the stand, you are waiving your Fifth Amendment right. The judge explained that to Kyle. In this case, he said, once you waive it, the district attorney is going to be able to cross-examine you. Do you understand that before we start? And he says yes. So they can't do that, but good question. All of these things happened, and then lawyers came and had to fix those rules or change those rules, or when they wrote those rules, somebody asked this exact question, and they put into place, what do we do in that situation? That's what we do with all the rules. So good question. This is what it's like when we sit around and talk about what edits need to be done to rules that we have. So Tom Rennick, if he's acquitted, he will not lose the right to own a firearm. All right, let's see. No problem, Hanky. And again, it's hard. I don't expect everybody to watch every second of this trial or understand everything that's said. So if somebody says something in the chat that's wrong, I'm happy to talk about it. I'm happy to give you my position on it, but I don't think you're like trying to throw stuff out. So if I acted like that, I apologize. Can you explain reckless endangerment? You're endangering other people because you are doing something recklessly that is dangerous. So there are certain things like if you close your eyes and spin around with a nunchuck, is that dangerous? Probably. Are you going to get charged with reckless endangerment? It depends. Did you know there was a lot of people around? There's a lot of factors. If you shoot a gun in a crowd of people unjustifiably, then you're probably recklessly endangering them. Now, if you're in self-defense and you're protecting your own life, then that can be a defense to reckless endangerment. Joe Mulcahy, sorry, I'm sure I butchered that. Why are the detectives sitting with the prosecutor throughout the trial? Is that normal? Absolutely. Totally normal for a detective to sit with them. In federal cases, the FBI agent will sit with the assistant U.S. attorney the whole time. They've put a lot of time and energy and work and resources into this case. They are the investigating officer usually, and I think the guy that's sitting at their table is their investigating officer. They can help throughout the trial, say, oh, here's this paper, here's this person I interviewed, this is what they said, kind of like a client, because obviously the district attorney or the state attorney or the government doesn't have an actual client. They represent the people of their county. Mitchell Rockensire, has the DA asked many bad faith questions in your opinion? I would not say many. Some have been pretty bad in my opinion. So, Diane Grant, is it possible that Kyle could be subject to a civil lawsuit after this trial? On what charges? Maybe the possibility. Absolutely. Just because you're not guilty of murder, if that is the verdict, which it's not yet. I think some people are making some assumptions too, which is why when I talk about a deal, I'd rather guarantee all of those charges go away if I'm Kyle Rittenhouse. But assuming he's off on the murder charges, all these victims can still file civil charges against him and still say he acted dangerously. It can be it's a battery, basically, battery with a deadly weapon. Even there could be some punitive damages for his actions. It's an intentional tort. That's what you can civilly charge him with as a victim, or even negligence for some of them, like McGinnis potentially wasn't meaning to shoot me, but because he shot him, that was negligent and accidentally hurt me. Is it still self-defense if the attacker backs off and Kyle racks his weapon and still shoots? So one of the things here, Rodney, that we always say is definitions are important and words are important. And the phrase here that you have is backs off. So to define backs off, I think is important. If somebody backs off but points a gun at you, are they backing off? I will tell you this. If somebody turns around and runs away and you shoot him in the back, then it's not going to be self-defense most of the time, I would say. All the time. I hesitate to say that because it always depends. But just taking a step back and aiming a firearm or And I'm not sure this is what the evidence showed, so I'm gonna put that caveat in there too. I don't think the evidence has actually shown that he racked the gun, according to the video. But just taking a step back is probably not enough because they could still lunge forward. It's if the danger has gone away and you still shoot, then it's not self-defense. Yeah, Megan, good point. Yeah, the burden of proof in civil is much different in criminal. It's beyond reasonable doubt. In civil, usually it's preponderance of the evidence are more likely than not. Frickendell. The defense was talking about a mistrial with prejudice. Can you explain what that means? So a lot of times when you have a mistrial and the judge throws out the case, you have to do the trial all over again. Well, the defense, I think, feels like it's going well for them so far. So they don't want that, but they want to protect the record for a mistrial. So they asked for a mistrial with prejudice, which is unusual, but they went through some of the exceptions that could potentially make that happen. And one of them is prosecutorial misconduct or the prosecutor acting in bad faith. Yeah, Brian Money, you got to be there while it's happening. You can't now if you see it on like a FaceTime and you run over there while it's still happening, I guess potentially, but you got to be there to stand in their shoes. Yeah. All right. I think that's it. We'll finish with this JD day one. Motion to dismiss. Does defense have to submit a motion to dismiss prior to the end of trial? It was yesterday a formal motion. So you can make verbal motions at times, and you can make them in court. An oral motion still counts, especially during the trial. Nobody expects you to go back and write a formal motion to dismiss. There are certain things that have to be filed formally after the trial, but that is not one of them. A mistrial or to dismiss the case with prejudice doesn't have to be done in writing. All right, the trial is back on, so everybody hop back over there. Thanks for joining us for another lunchtime update. We will be back Monday, hopefully with another live. Maybe we'll have a verdict by then, so make sure you guys all catch the live then. Don't forget to subscribe and come back for more. Thank you, everybody who got in the comments and made this fun. Until next time.